Thank you. Thank you for that excellent presentation. Our next speaker now is Professor Gail Henderson, who's going to give us some insights from Canadian human rights law.
So the name of this conference is We Make It Happen, it being sustainable companies. And the question we are attempting to answer here is, how do we make it happen? And specifically, how could corporate law make it happen? And if the UK is going to be the last jurisdiction to implement these changes, then I'm sorry to tell you that Canada is probably going to be the second last country to do so, but I will be ready with my law reform proposal when we finally get there. So it's unfortunate that I don't have the visual aid because I use the very technological advanced tool of clip art in PowerPoint to show you a set of scales. And so up here, with very little weight put on it, we have environmental sustainability, and down here, with still a lot of weight put on it, we have profitability. So we need to do better at balancing the scales of these two things. The one thing that companies do now, generate profits, and the thing we want them to do, which is to be more environmentally sustainable. So the problem is currently, as many other speakers have mentioned, is that profitability is the sole object and the overriding priority of the corporation and its board, as dictated either by law or, as we've discussed, by the norm of shareholder primacy. So I share the view of earlier presenters that we will get sustainable companies only if we expressly require boards of directors to balance profits and environmental sustainability. The question is, how can a board strike this balance? And I think we can't simply tell boards to do this. How will they know when they are putting too much emphasis on sustainability and too little on profitability, and vice versa? So if boards are to strike this balance, they need a legal framework that sets out as clearly as possible what is expected of the board and when the board can know that it has fulfilled this expectation. So I suggest that we can create such a legal framework by borrowing concepts developed in Canadian human rights jurisprudence. And specifically, I'll talk to you about the minimal impairment test developed by the Supreme Court of Canada in constitutional rights cases, and the undue hardship test developed primarily under human rights codes applicable to private organizations. So the first step in creating a legal framework to balance profitability and sustainability is to amend the statutory duties of the board to expressly include a duty to minimize the firm's environmental impacts. So this was an idea that I first presented at the Sustainable Companies Conference back in 2011, and that paper was published in the International Comparative Corporate Law Journal in 2012. In the paper submitted for this conference, I explain briefly why I focus on the board, why I characterize the duty as a duty to minimize, and what I mean by environmental impacts. And I'm happy to discuss these aspects of the proposal in the Q&A, but in the limited time allotted, I'd like to focus on how I think Canadian human rights jurisprudence can be helpful to the Sustainable Companies Project. So first, to explain the content of the duty to minimize environmental impacts, I borrow from the minimal impairment test applied by Canadian courts to determine when an infringement of a constitutionally protected right is justified in order to achieve an important government objective. So the minimal impairment part of this test requires the government to demonstrate that the action taken to achieve the objective impairs the constitutional right as little as reasonably possible. So in other words, the government action must be minimally impairing of the right while still achieving the government objective. Okay, so those are the scales. Okay, thanks, Beata. Okay, so I was talking about minimal impairment. So it has to be minimally impairing of the right while still achieving the government's objective. So in terms of the duty I propose here, minimal impairment means that the board must inquire whether there are less environmentally harmful means of achieving the corporation's objectives and to ensure that the means chosen impair the environment as little as possible. Now, in general terms, the corporate objective is to generate profits. This is the reason that companies engage in a particular industry or economic activity. In fulfilling its duty to minimize environmental impacts, I would say the board is not required to decide that the company's chosen industry or activity, so extracting oil from northern Alberta, for example, which is where I live, it's not up to the board to have to decide that this activity is so inherently environmentally harmful that the corporation must cease this activity. The board could decide to do so because it sees that maybe over the long term this isn't a sustainable way to generate profits, but the board wouldn't be required to do so. And that I see as the role of government, right? It's the role of a democratically elected government to say this particular activity is so harmful that we're going to prohibit it completely. But if the government decides to allow a particular industry or activity to continue, then the role of the board is to make sure that it's generating profits, for example, by extracting oil, in a manner that minimally impairs the environment while still generating profits. Now, if the corporation's objective is to maximize profits, then the board won't be required to take any environmental measures that reduce profits, and so the duty to minimize environmental impacts would not actually balance profitability and sustainability. This same problem has arisen in the Canadian constitutional rights context. Supreme Court Justice Rosalie Abella has noted that it would be easy for the government to show that only the means it has chosen will maximize the government's objective. But under the minimal impairment test, the government is not entitled to infringe rights solely to maximize a given objective, no matter how important that objective might be, when a less intrusive means would sufficiently achieve the objective. Similarly, the corporate objective against which environmental sustainability is measured should not be maximization of profits, as a number of people have discussed already, but rather a level of profits required to keep the company competitive or to keep it viable. So, using this understanding of the corporate objective and board obligations, how far does a board have to go in preventing and reducing environmental impacts before it can say that these have been minimized? In other words, at what point can the board say that they have balanced profits and environmental sustainability? Under Canadian human rights codes, a private organization has a legal obligation to accommodate individuals' human rights up to the point of undue hardship. So, for example, in one case, a Canadian passenger rail company argued that the cost of widening the aisles of its rail cars in order to accommodate wheelchairs, that this would cause the company undue hardship. So, in other words, the cost of accommodation would threaten the profitability of the enterprise. Undue hardship doesn't require that the cost of accommodation put the corporation on the brink of bankruptcy, so that's not what undue hardship means. It's somewhere in between no harm and fatal harm. And it will depend on the specific circumstances of that corporation. So one factor that the courts might look at is the percentage of the cost of accommodation as compared with the company's revenues and profits. So if the cost is a very significant percentage, then the company might be more likely to succeed in an undue hardship argument. If the percentage is very insignificant, it's less likely to succeed. But perhaps the most important aspect of the undue hardship test is that it puts the onus on the board to demonstrate why it can't implement a particular measure that would prevent or reduce the corporation's environmental impacts. So in my last minute, I'll just go back to these wonderful graphics I've prepared. So under their existing duty to the corporation, measures to prevent or reduce environmental impacts tend to be implemented only if it can be shown in advance that they will enhance profits. So in order to balance the scales, we need to reverse this onus and require the board to take measures that reduce environmental impacts up to the point of undue hardship to the firm's profitability. So achieving this balance requires that boards minimize environmental impacts rather than maximize profits. Thanks very much.